And for respondent number 5, Lordship, no objection, Lordship.
Respondent is the school manager.
Yes.
When do you want it?
After 2 weeks, Your Lordship.
19. At the request of the petitioner, list after 2 weeks. Yes.
Highly obliged. Daily costless, item number 1.
Yes.
Lordship, this matter is yet to be settled actually. This issue, I mean, the issue regarding under which act or
Okay, whether
we have-
CFPC will be, whether it will be under
whether the new
or
act or the old procedure will be applied.
May I please, Your Lordship, that this matter must be end of the board. Conducting counsel is engaging in another court,
Not the
Lordship.
end of the bed when it will come. You see, this court has 2 division benches there.
Yes.
We do not know once we rise when we come back or not. Then
No, I think
things are unpredictable. We can keep it, but then it's up to you.
so. I pray that it may come up after a week or so, after the issue regarding this.
What is the otherwise? What is the subject matter?
The subject matter is regarding. There was a actually the case had ended in a
Compromise.
no, in the final report, Your Lordship, and the complainant was not happy about it. So he has prayed before this court that the investigation should be reopened and the accused against whom he had filed a complaint should be directed to be arrested.
So now, if
And then there is a private respondent is also there, Your Lordship. So in
okay, so
that
it is
case,
against acceptance of FR.
yes, Your Lordship.
So how much we can do in this matter then? If investigation doesn't find any evidence
Yes.
against somebody, what court can do under 482?
He wants that the investigation should be reopened and the accused person should be, I don't know. His prayers for directing the investigation officer to investigate the case and to file the charge sheet against the private respondent and other co-accused persons.
To file the charge sheet, can direction be passed like that? Huh? Is it possible in law to pass a direction directing to police to file a charge sheet? We may direct the police to investigate a matter, but then can we go to that extent? So what do you do? Now, what happened to that about the application of that the
The new act, and I think it was fixed on the 25th, on which day the chief was not available, and so the matter is still unresolved.
We do not know then what is to be done.
What is under which act they are to file this?
And then this is the most procedural aspect. I don't think.
Because the incident occurred prior to the act coming into force, the new act coming into force. So whether, anyway, Your Lordships.
But this is a case which
different
was
high courts
registered-
have given different conflicting views, which is why we are a little uncertain.
Do we have the copy of the new act? Do we have the new act has come or not? That- Bharat,
I don't have
Bharat Nagarika Sangh. Okay.
new act. The 351 or something is there? Just check 351. There. 531.
There remains no doubt about the application of CRPC here in this case. Just see that. Do you have that?
I don't have the act with me.
This BNSS. See that section 531. 531 2A.
Yes, Your Lordship.
So there remains no doubt. It
As if
covers up
this
the arena of
Samhita had not
investigation
come into
also.
force.
Investigation also.
It was pending. The incident, the alleged incident took place in April, I think.
You will do one thing, will issue notice instead of
Yes, Your Lordship.
delaying
To
the
the private, yes, to the
will
private.
issue notice. Then. Yes, hard. So and so. That will remain open if you later on, if you
Yes,
find there is some,
correct,
then
Your
we will
Lordship.
see it.
After decision is taken by the division bench.
Yes, issue notice. Returnable in 3 weeks. MS Ingi Learned AG appears along with so and so. Appears on behalf of respondent number 1, 2, 3, and 4. 5, you have to take steps. Stop. The petitioner shall take steps for service of notice upon the private respondent number 5. Within 2 days. List after 3 weeks.
Hi, Your Lordship. Item number 2.
Look, I have just received the affidavit filed by the state, my lord. But there are certain discrepancies in the facts. So I'll just file a short rebuttal, my lord, to these factual aspects.
Do not make it a see, this is a criminal revision.
Yes, my lord, but these factual aspects are very important because it talks about a private limited company. However, they mention that it's a proprietor.
If there is a factual dispute, this court will not go to it.
Yes, my lord.
That is for sure.
Yes, my lord.
Even if you give a reply, you do not give a reply.
Lord, just kindly allow me to have the rebuttal on record.
Do not want to encourage that practice, Mr. Nopri. This is spoiling the things. I have seen the
rebuttal
matters,
to
there
the-
are 6, 7, 8 affidavits filed. Only thing is because one party raises one contention, other party reverts it by things.
No, my lord, I just need to rebut, my lord, certain factual aspects.
That is
I will not raise anything new, my lord.
See, even for rebuttal also, say supposing if your rebuttal comes, this court will not go into all those factual aspects to decide a matter.
Certainly, my lord. I do understand this
We
matters.
have a very limited jurisdiction.
Yes, my lord.
So whether you rebut it or do not rebut it may not have any, you see, like material bearings so as this case is concerned.
My lord, then kindly have it for hearing.
This is a revision, isn't it?
Yes,
Revision, my lord, because the
We will see
Zimma petition.
if there is any serious difficulty,
Yes, my lord.
then we will do that.
My
See,
lord.
Mr. Nongri,
Yes,
you can understand maybe in exceptional 1-2 cases we can do it. But then once it becomes a practice, then you see like
My lord, in this,
revision application,
Yes,
you'll
my
find this matter.
ultimately in this matter, your lordships will not decide on merit. The only issue is that the court below has not decided the application of Zimma on merit. That
Because
is
of
the
the
only question.
pendency of a matter
Yeah,
before
Yes,
division bench.
yes. So I'll kindly have it for hearing. In the meantime, my lord,
But even then, do you think this court can give any relief to you? Why don't you approach the division bench?
my lord, we have already approached with respect to the my lord, modification of the order due to my lord, the matter not being listed for a long
Then
time.
you withdraw it.
No, my lord, let us wait, my lord. If I succeed there, then your lordships can always remand this back to the lower court for proper
If you succeed
adjudication.
there, your option will automatically there to approach the trial court. You do not have to get an order of remand.
My lord is correct on that also, my lord.
It's a matter of pending.
My lord, for withdrawal, I will have to take instructions, my lord. Just have it for hearing, my lord. We'll try, my lord.
Yes, it is. It is submitted on behalf of the state respondent that an objection has been filed in the matter. the parties submit that matter is ready for hearing. This is matter for hearing after 2 weeks.
3 weeks.
3 weeks.
Duly noted.
Item number 3.
My lord,
Yes.
on 15th July, my lord has directed us to file the service report
Yes.
on respect of respondent number 2, my lord. We have filed, my lord, at its own record, and the service has been received by respondent number 2, my lord. So I don't know anybody is coming, appearing on his behalf or not.
Davis Nestle Rangsa. Is a person?
Yes, my lord.
Samara.
Yes, my lord. He is the complainant.
Yes. So he has received notice, but
He has received notice, my
no
lord.
one is appearing. You have any instruction? No.
No instructions.
No instruction. So, only of the private respondents. Okay. Yes. The Learned Counsel for the petitioner submits. Then that submits that service affidavit in respect of service of notice upon the respondent in respect of respondent number 2. In respect of respondent number 2 has been filed showing the factum that the said respondent has already been served. Stop. However, when this matter was called out, none entered appeared for the respondent number 2. What is to be done today?
My lord, if on a next date, if it doesn't appear, we can go for hearing, my lord.
Are you filing anything? No, you are not filing anything.
No, no, Lordship.
Okay, just explain for the parties. This is matter after 2 weeks.
2 weeks, my
We'll
lord.
just see. Next day, just point it out if it doesn't.
My lord, my lord. Obliged.
Item number 5. Number 6.
Yes.
Please, Your Lordship, in this matter, I'm praying for some time.
Refused.
Your Lordship, Mr. Paul, he's having some medical urgency in the house, so here
You
on.
proceed. You can do it. What is it? What is there remaining? Just tell us. Place the fact of the case and then we'll see. What is the problem? What happened to Mr. Paul?
His mother is not well, Your Lordship.
He's still not well.
Still not well.
No objection, my lord.
That is very expected from this.
My lord, since health is a
Definitely, definitely. We can understand. You are there. You are appearing for? No serious objection? Okay, okay. A prayer has been made on behalf of the petitioner on the ground of personal difficulty of Mr. K. Paul London, Senior Counsel. Stop. The prayer has not been objected to by the learned counsels for the respondents. When?
Lordship, after 2 weeks.
Then give next line. List this matter after 2 weeks.
Highly obliged.
Item number 7.
Yes.
But the matter relates to the Employees Provident Fund Act, my lord.
What is writ petition?
Writ petition, my lord, because certain coercive action of initiation of my lord, criminal proceedings under the EPF Act was, my lord, notices were issued to us, the Meghalaya Urban Development Authority, regarding these STPS buses, my lord, these red buses running in town. Now, my lord, this is a scheme, central scheme, which
The
is
order which is under challenge here,
yes, my lord.
parties to what? No appeal lies under that.
No, my
Appeal
lord.
lies, Lordship. 14B and
If
7.
appeal
Lord,
lies,
the,
this
the
writ
question
petition-
is the question is, my lord, the notice to for prosecution, my lord.
Madam, you have raised this plea that there's a provision of appeal in this, and the writ will not be maintainable.
Lordship, initially, actually, Lordship, in this case, Sayaldi Chaudhary was there during his
So it
time.
was not raised. So now you are raising that.
Now, after I got
Anyway, this is a
amended,
question of law. We can always adjudicate.
Yes.
See, you must be aware of the recent Apex Court judgment with regard to the matters where statutory provision of appeal is there. In order to make a writ petition maintainable, there has to be a specific assertion why you have not preferred the appeal and why this writ petition.
My lord.
So is it there in your thing?
My lord,
Otherwise, we will direct you to file an appeal.
there is nothing.
my lord, I'll have to check on the appellate, my lord,
Provision.
provision, my lord.
Yes, just give,
7I.
give him the things.
7I.
She's there, she can help you. See, what is the provision she can say? Give us the EPF Act. Do you have?
It's a 7I, Lordship. Order to tribunal. Order of 7I. Sorry, appeal to tribunal. It's appeal to tribunal. 7I and 7L is order of tribunal.
My lord, what we are challenging before your lordships is, my lord, the
Tribunal. A person agreed by notification any order passed by the central government. What is under challenge here?
my lord,
Section
the
14B.
notices.
Section 14B
Notices.
and
Now, if your
it's- Lordship, here the order was passed, Lordship, under section 14B and 7Q. So both the orders means like 14B is under means it's an appealable order, Lordship. So
I'll
once
just take to your lordships, my lord.
Yes.
My lord, I'll just take through the appeal provision, my lord, 7I.
Yes.
Any person aggrieved by a notification issued by the central government or an order passed by the central government or any authority under the proviso to subsection 3 or subsection 4 or section 1 or section 3 or subsection 1 of section 7A or section 7B, except an order so and so, or section 7C 14B may prefer an appeal to the tribunal. Now the issue here is, my lord, 7A has not been initiated as yet. Show cause notices have been issued to me. Why 7A proceedings should not be initiated against me? So that is why, my lord, I have come.
So this is an order under what?
14B.
If it is 14B, that also applicable.
Appellable, Lordship.
It's not under 14B, my lord. It's just a notice, my lord. (14) is penalties. Up till now, penalties have not been imposed, my lord. Section 14 deals with penalties. Now, the very question that I'm raising in this writ petition is, my lord, regarding.
Yes.
Yes, my lord. Page by have the challenge.
What is the notice? Notice under challenge? What page?
Would kindly have the last notice, your lordships would find. Last notice is, my lord, annexure 17, page 151.
How many notices under challenge?
Several notices, my lord,
And these all are relating to the same purpose.
relating to the same purpose, my lord, because in relation to these notices, we have replied to them, my lord, to the authority, saying that these are the operators. We have provided the names of the operators. Kindly issue notice to the operators. They are liable to pay. Me as an executing agency, my lord, I am not an employer. It's a scheme of the central government, my lord, and it is the state government, my lord, who own these buses. As MUDA, I am only an executing agency. So, my lord, I have issued a reply. Despite my reply, my lord, again and again notices have been issued.
Where is the notice? Just show.
Yes, my lord. Kindly, my lord, start from page
Page 133, Lordship.
133 onwards is the notice, my lord, in January 2018. And, my lord, page 134 is my reply to the notice.
Just a minute. Let us see what is there in the notice. What is MP Act?
Miscellaneous provision.
Acha. This. Well, we'll continue, Mr. We'll have to continue.
My lord.
Lordship, my senior got engaged in another court, so kindly allow us to take the matter in the end of the board.
End of the board. Yes, Mr. Nambri.
Okay, my lord. I'll start with the other matters. I'll start with the other matters.
Pleasure.
Okay, we just call it at the end of the board. Yes.
Item number 8.
End of the board.
Yes.
Watching this matter, I'm also going for some time, Your Lordship.
What is this matter about? No?
Your Lordship, this is a criminal petition, Your Lordship.
For seeking quashing of what? It is against what?
This is an NDPS case, Your Lordship. And it's the sub-inspector has registered the case. He has investigated and charged the case, whereas under the Drugs and Cosmetic Act, he is not the authorized person, Your Lordship, the sub-inspector.
That is the issue.
Lordship.
You are ready to reply that.
Lordship, even I think this matter is being led by Mr. Subhashis Sen, Lordship. I'm not mistaken.
When do you want it?
Next week, Your Lordship.
At the request of the petitioner, list after a week.
Lordship, may make it after 2 weeks, Lordship.
You are also asking for time. Just say on the
Lordship, since you're asking-
on the joint request, list is met after 2 weeks. Just cancel the RD order. Yes.
I do, Lordship.
Item number 10.
We have reached the end of the board.
Not yet, ma'am. Yes, ma'am. Two matters.
Yes, yes. All right. Yes. Yes.
The state is a necessary party in this case. Sir.
State is the main party, ma'am.
Is it? Where is the state? Who is appearing for the state?
Mr. Shulai is leading in the matter for the state.
Yes, yes. Let him be on legs. You can sit here.
Well, I'm here. My senior colleagues want to finish. They want to make a submission accordingly. Senior can reach on that. Otherwise, we'll the next day.
See, we will not do it in piecemeal. See, like this court has very, weak memory. Now, when the day is over, it forgets everything. So that is what the problem is. It should not be something like that. Mr. Nangri argues today, Ms. Bhattacharya argues today, and then you.
We'll have it after 2 weeks.
Yes, just see the issue of maintainability. That is one part of these things.
Yes, ma'am.
It is order is applicable.
This matter pertains to pay, ma'am. To pay. Now, this post, my lord, is a post of community organizer in the Juwai Municipal Board. Community organizer. Now, in the remaining municipal boards of the state, my lord, a certain pay scale has been granted to this particular post. However, in Juwai, she is not being granted. Now, my lord, the contention is that this post is not permanent post. Now, even if that is the case, my lord, I'm still covered by Jagjit Singh, my lord, for at least the minimum pay. Jagjit Singh was the state of Punjab, so that is
the issue there.
That's the issue.
Okay, just at the request of the state respondents. List is met after 2 months.
Item number 11.
Item 11 is this matter with Mrs. Sen.
Yes.
Regarding the domestic violence.
Yes.
On the last occasion, my lord, your lordships had directed me to place on record the notice which was received. My lord, I have got a copy of the notice in a sense like they have sent it to me through the phone, mobile. My lord. I'm just waiting for the hard copy. I'll file an affidavit. My lord. to bring it on record.
You can hand it over to us also. You do not have to file an affidavit. Is it tricky to file an affidavit? Well, we'll just see it first.
My lord.
These are criminal petition. We do not want to have affidavits after affidavits. Anyway, if you think that for bringing a record, bringing a part of record, okay.
That liberty may be granted.
On the last occasion, we did not pass any order
No.
asking you to furnish any of this thing. So we'll just adjourn it. You do it by yourself. Then.
Yes. Because the liberty to bring it on record has to be granted. Otherwise,
This is a matter. It can't be sent to mediation center, mediation committee.
We've tried, you know,
Mediation
the
commission-
dispute is only on that quantum.
I'm ready.
I don't mind that actually, I don't mind that.
No, if it helps, then we can at least see, because these are.
Matrimonial issues.
See, this is very, for a court, it's very unpleasant thing to pass some order in. Of course, we should not be guided by this thing. This is a personal thing, it's expression of personal things. That is what this court is doing. So, like, in not only this matter, in all kind of family matters,
Yes.
this court desires that there should be at least, the best effort for,
One
attaining
attempt,
some amicable settlement.
one attempt can be made, my lord, because ultimately it is only the amount. It's only the amount.
So, shall we send it to mediation?
I have no
committee?
difficulty. Just with the only caveat, Milons, that the trial court proceedings should not be stalled in any manner.
That should not be. Why should we? You are sending this, you see, it cannot be
That's all.
by any stretch of imagination that cannot be.
No, what happens is because in these cases, the parties have come forward and told the court that there's a settlement pending, so therefore the case should not go forward. Only for that, that's my only anxiety, Milons. If that can be taken care of, at least then in that case, they will not come and seek adjournments, unnecessary adjournments before the trial court. So it can be sent in the meantime. We'll try our best to try and settle the matter. Because it makes a lot of difference with the help of trained mediators as well.
If you have, see, like if it is that, say like at the same time you say that this trial court proceeding should not be hampered, that means like there will be this will be a futile exercise sending it to mediation center.
So Milons, what happens, if I
So
may...
you have a mind to, proceed with the thing. That is what actually you see.
Lordship.
So with that, if we have that expression,
I'll be very candid, my lords. In my experience, I've seen people stretch the proceedings unnecessarily and on the same collateral trial court that since so-and-so is pending, please don't proceed with this case.
definitely, but at the same time, it speaks of your interest also to get the matter settled.
Lordship. So I'm interested in disposing of this case. I have no difficulty with that. Mediation, if both the parties genuinely want to try and
If
settle
you
it, I
are
have no
not
difficulty.
agreeing for mediation, this court will not force for mediation. So we'll decide this matter there. What is it?
Either way, I'll leave it to your lordships.
Lord, kindly send it for mediation, my lord. Such issues, my lord,
he's-
an endeavor should always be made, my lord.
If he is not at all,
No, only with that condition, my lords. Just with that condition. It should not be used as a tool to try and delay the proceedings. That's all.
okay, hard learned counsel for the parties. So during the course of hearing, Mr. Nangmi, learned counsel for the petitioner, expressed the desirous of the petitioner to have the matter settled amicably. Mr. Shan, learned counsel, appearing for the respondent, does not oppose the expression of desire by the petitioner. However, he makes a submission that the proceeding to the trial court should not get hampered by pendency of this matter for amicable settlement. Stop. Both the parties otherwise agree that involvement of a mediator in the matter may help the parties to come to a settlement. Paragraph. In view of the above, it is deemed proper to send the matter to the mediation committee. High Court, what do we call it? Mediation. Just verify it from this thing, right? Whether it is High Court Mediation Committee or Mediation Committee of the High Court. What we said? This way of the. Accordingly, let this matter be placed before the High Court Mediation Committee for what shall we say? What they do? They engage some mediator or the committee.
So they have a list of mediators, and the parties are summoned to appear personally, and they try and engage in a
to take necessary steps.
Lodge.
For arriving into a settlement in the matter.
Lodge.
Do you have to say the registry will place it before the thing?
I'm not sure what the modalities are. Lord.
Registry. Let this matter be placed before the mediation committee. Let registry place this matter before the mediation committee for doing the needful. There may be one to correction little. We do not fix it, because can we fix a time for? I don't think that will be proper.
Well, let the committee fix, because it's not a permanent committee, depending on.
It is made clear that pendency of the matter for mediation shall not be cited by any of the parties to seek adjournment before the trial court.
Highly obliged.
That will do.
Obliged.
Second call, item number 7.
Do we need to pass any order listing the matter again after? No, we cannot.
They will send it back. In case there's a failure, they would send it back.
All right.
Obliged.
Lord, we were at page number 133, my lord.
Yes.
Annexure 2. So, Lord, this is the show cause notice issued by the EPF, my lord.
Page 133.
133, my lord. If I may read, my lord. Subject non-compliance of EPF and MP Act. It has come to your notice that so many employees, including permanent, temporary, casual, daily wages, piece rated and contractual, etc., of your establishment, including employees of Shillong Transport Service, have been deprived from Provident Fund benefits. It has further come to our notice.
That means not only the employees who is engaged with the Shillong Transport Services, but your own employees.
Your own employees. It has further come to our notice that the Shillong Transport Services is operated by you, but all employees engaged with these services have been deprived from the Provident Fund benefits since the date of joining. So it says that operated by you, operated by us. As you have violated the EPF rules, you are liable to be prosecuted as per provisions of para 76 of EPF scheme 1952, read with section 14 of EPF MP Act 1952, for which a penalty up to 25,000 and or 1 year imprisonment may be imposed. But before initiation of any legal proceedings, one more and final opportunity is being given to you, and you are hereby directed to produce the following record at our office on so and so positively. Number 1, attendance, salary, wages, vouchers, registers from 1st April 2012 till date in respect of all employees, including Shillong Transport Corporation and various contractual employees. Cash book, ledger, balance sheet with profit and loss accounts.
What is your response to this notice?
Yes. Now, next page. Page 134. Yes. So immediately, my lord, we issued this reply, my lord. It reads, my lord, With reference to the above mentioned subject, we are in receipt of a show cause notice for prosecution for non-compliance of the EPF and MP Act 1952 by depriving Provident Fund benefits to many employees, including permanent, temporary, casual, so on and so forth, of our establishment, including employees of Shillong Public Transport Services. That with respect to employees of MUDA, we have wide separate replies shown our compliance in payment of Provident Fund. So that is our employees. However, coming to the second aspect of the notice, in relation to the employees of the Shillong Public Transport Services, it may be clarified that the employees of the Shillong Public Transport Services are neither directly nor indirectly employed by MUDA, that the buses under the Shillong Public Transport Services are being run in implementation of the Jawaharlal Nehru National Urban Renewal Mission Scheme, that the scheme was launched by the Government of India under Ministry of Urban Development for bringing improvements in civic services, that the scheme was launched in 2005 for a period of 7 years, that MUDA is only the implementing agency and not the owner of these buses, that being the implementing agency, the role of MUDA is to procure the buses and hand over the possession of the same to the selected operators, that the selection of the operators is being done by way of a tender process, that the buses are registered in the name of the Urban Affairs Department, Government of Meghalaya. That being only an implementing agency, MUDA cannot be said to be...
No, but then who is in charge of those employees? That is the main thing.
The operators, MUDA. The operators.
That means the state.
No, Lordship. Actually, the agreement, what they have, if we go to the agreement...
Wait, madam, we'll just come to you. We'll come back to you. If it is a detailed submission, then it's okay. Just wait. Let him finish.
It's not a detailed submission, just I'm taking Lordship to the agreement. The agreement is stating that they have signed an agreement with the operator, and therein, as per the agreement, they are the principal employer. The MUDA is the principal employer. That's...
If I continue to read.
Yes, sir.
That being only an implementing agency, MUDA cannot be said to be the directly or indirectly employing the employees of the Shillong Public Transport Services, even more so when MUDA is not the owner of the bus. That, in other words, MUDA has only engaged the operators for running the buses, and that it is the operators who engages his staff to run the buses, and hence...
Say operator means what? By saying operator, you mean whom?
The successful tenderer, my lord. The various operators by tender, the successful tenderer are given certain routes to operate. So they are the operators, my lord. And there's a standard.
The employees, their employees. They're
employees.
Now, who was in operation that relevant point of time when this notice?
Yes, my lord. I'll just take your lordships to the next pages, my lord.
So you are not saying that is government responsibility also. You are saying it's operators' responsibility.
Operators, my lord. Operators.
Operator is a private body.
Yes, my lord. And since the government is the owner, my lord, if they are to claim from the government, my lord, government is exempted, my lord, under the Act, my lord. Now, my lord, at page 136, again.
Now,
this
is a notice. This is a notice.
Yes, my lord.
That is basically is in violation of what provision of law?
My lord, these are a series of notices, my lord. Thereafter, we have come before your lordships.
No, that is okay.
Yes,
these notices are issued when?
My lord, notices are
when
issued.
You pay to make contribution.
Yes, my lord. Now we are saying we are not liable.
Contribution is provided in what provision of law? What section?
My lord, contribution.
Your liability.
Yes, my lord.
Or the employer's liability to contribute.
Yes, my lord. That has to be determined under section 7A, my lord. 7A. Now, my lord.
Now 7A again is applicable.
If an order under 7A is passed, this is before 7A, my lord. No notice, my lord, issued to us, show cause notice, but then initiate 7A.
It speaks about prosecution, isn't it?
Yes, my lord. It speaks about, my lord.
Then how can a prosecution take place without any order under section 7A? See the last part of the notice at annexure to page 133.
Yes, my lord.
The last paragraph, if you see, please note that
please note that no further extension will be allowed. And if you produce called
Under the section 7A.
my lord, I'm saying, my lord, the issuance of these show cause notices and my reply thereafter, my lord, I provide the list of operators, my lord, and time and again you're issuing these notices.
We'll just come to facts.
Yes,
All
yes.
right. Just see this. You have expertise so far as this provision of law is concerned. This court
No,
doesn't
my
have.
lord, no, I'm
So
sorry.
you have to just make the basic, just clarify some basic
Yes,
understanding.
ma'am. Yes.
Now what happens? Assuming that you are the employer, the law makes you liable to make some contribution in the PF account. You do not do it. Now when you do not do it, a notice is issued. Now this notice, issuance of his notice under what section of law?
It does not
The
mention.
authority is empowered with the power of issuing notice, isn't it? In case of any default. Now what provision of the Act first makes you liable to make contribution? And what the law says, what happens when that provision is contravened? When there is any contravention?
No, the notices don't mention the provision of law under which the notices.
How can be noticed? Then what is the provision? Then what is the provision? Just take us to the provision by which you are liable to make contribution, and the provision which speaks of the follow-up action in case of violation.
Yes, my lord. Lord, kindly have section 1. Why the operators and why notices being issued to Muda? Lord? My lord, section 1 reads, this act may be called the so-and-so.
Yes.
And subsection 3, my lord.
Yes.
Subject to the provisions contained in section 16, it applies to A and B, my lord, to every establishment which is a factory engaged in any industry specific in Schedule 1.
We are not on that.
In which, my lord, this figure of 20 is very important, in which 20 or more persons are employed.
Yes.
Similar with B, my lord. So 20 and above, my lord. Now, my lord, it is for these operators, my lord.
You are still basically dwelling on the same part, whether it apply to you or not.
Yes, my lord.
We have not asked you any question with regard to
Yes, my lord.
We just say, just assume a situation
Yes, my lord.
where you think that yes, you come under the purview of the Act. Okay, just assume it. Then what law makes you, what provision of law makes you liable for contribution, making contribution?
Just give me a moment, please.
Please.
Lordship, if I may assist Lordship, it is the section 1(3)(b) only, where the employer is having more than 20 employees.
That is okay. Let us assume that for the time being,
Yes.
that
So
he comes
the-
under that category.
So if a principal employer, if we take Muda as a principal employer, under principal employer, if 20 or more
See,
employees
madam,
there,
two things. This court is aware of these things.
Yes.
This notice pertains to two set of employees. One is the employees, those who are directly under them.
Yes.
One under the SPTS.
and under this
Now, according to him, SPTS employees are not under him,
Lordship,
so cannot be held liable for that.
Lordship,
But then he says that he is liable for his own employees.
Lordship,
Now, your notice concerns his employees also.
his employees also.
So right now we are not making any distinction or classification between two things. If notice concerns one set of employee also, then the notice will be treated as valid.
Lordship,
So for partially may not be valid for those set of employees, but then this he can say elsewhere, okay, where you see, like it would be determined. You see, the fact is that he will have to answer himself about that also. Now, do you agree with his reply wherein he said that he has made those contribution so far as his employees are concerned?
Lordship, he employs the contractors' employees. The operators are basically the contractors.
Forget about those part. So far as his own employees are concerned, your notice has two sets of employees.
Lordship,
One under him.
one under him.
Now, his reply with regard to his employees is that they have made regular contribution. Do you agree with that?
Lordship, there is no such challans or no such documents where it
So you do not agree. So you're disputing that.
Lordship.
So even if this notice fails on the ground, the employees under SPTS is not his responsibility. This notice will stand on the ground. The rest of the employees under
Rest of
him
the employees, yes, Lordship.
is admittedly his employees, so he will
Yes.
come under this thing.
But here the challenge is only for SPTS, because the reply with respect to our own employees have been given separately, and we are saying we are
No, what
we
is
are
the reaction
depositing-
to your reply? Now, if they are
they have
also,
not-
if they maintain this, that means this notice will take into
they have not, my lord.
your own employees also, your own thing also.
They have not, my lord. In their reply, they also speak only about the STPS employees, my lord, not about MUDA employees.
Muda anymore. What is the latest notice show us? Because this 133 is with regard to two sets of employees.
Yes, my lord.
Both sets of employees are included here.
Now, my lord, the subsequent notices talks only about the operation of the
Where
bus.
is that?
My lord, 136.
There are certain things. These EPF has filed their affidavit.
Yes, my lord.
Have they clarified there? Have they taken a
No, my
stand?
lord. They only speak about STPS, my lord.
Lordship, in the last Annexure 17, Lordship. Annexure 17, Lordship.
If the facts are not been taken care of correctly, then if you do not deal with the facts properly, then it becomes difficult for the court to come to a conclusion.
151,
Page?
page 151, Lordship.
Yes.
Please refer to our various letters on the subject cited above. It is a matter of serious concern that despite our sincere effort, you fail to make compliance of our order, and neither all contractual employee were covered nor compliance of deduction of 25% of bills of each and every contractor was submitted to this office so far with effect.
See, madam, this subject of the thing, that is in respect of contractual employees engaged by the various bus operators.
Yes.
Not his employees. Page 133 is with regard to both set of employees.
Both center employees.
So it means, so far as his reply with regard to his employees are concerned, with those
That
which
is
he
not-
admitted,
that is
you
not
do
an
not have
issue.
you do not have any issue.
No issues.
Do not have any more issues. Now, who is the person who has been allotted with the contract of operating things?
Yes, but my lord, kindly have page
Are
130.
they party here?
They're not parties, my lord. They're not parties, because we are challenging the notices issued to us, my lord. Now,
Then
kindly have page
You are
137.
challenging on the ground that they are not your employees.
Yes, and we are not liable to make
Responsibility
payment.
of the operators.
Yes, my lord.
Now, is it
because
particular that
they-
operators, because this is a writ petition, it is
Yes,
not
my
a,
lord.
it is a writ petition.
Yes,
isn't
my
it?
lord.
Is it not required that there should be a party?
My lord, these operators, we have given them various directions, my lord, to go and register with the EPF, and they have gone and registered, my lord. So despite all that registration, again notice being issued to us, we are the affected party, my lord.
No.
As
how
the implementing
how do
agency.
we know that they have gone and they have registered?
Yeah, I'll just take your lordships through the
But
annexes.
then
my
this is your statement, that has to come from them only.
lord.
this
This is my
becomes
reputation,
a-
my lord. It's not going to affect
See,
their rights.
The evidence has to be always direct. That is what the
My lord,
mandate
correct.
of law.
Correct, my lord.
Cannot be indirect.
Correct, my lord.
Now, what I have done, it should not be through you.
Yes, my lord.
Experience. See?
Yes, my lord.
That is what. So we do not know whether they may not be at all necessary for adjudication of this matter. You have not claimed any relief from them also, so that is not needed. But then once there is an assertion that those sort of employees would be under those operators, then is it not required? Who is the operator?
Well, kindly have page 137. This is in March 2018 itself, after receipt of the first and second notice. We have issued notice to all the operators to kindly go and register with the EPF. So there were 10 operators, my lord.
Now, how many operators are there? Are 10 operators.
Yes, my lord, 10 operators.
And then this notice concerns the employees under
all of them, my lord. So that is why, my lord, section 1(3)(b) was important, my lord. If these operators do not come, if they don't have employees within the 20, it is for them to go and deal with EPF.
That will be a different thing.
Yes, ma'am.
Now, see, these notices were issued under assumption that those employees were this under you. Now you say that they are not. Now, the query which the court had put to you is that, assuming that, then what provision of law makes it liable for you to make contribution?
Section 6, my lord.
Para 30, clause 3 of EPF schemes.
But then the scheme has to come from this act, isn't it? What is
Yes.
the provision?
Section 6, my lord.
Section 6. This matter was never transferred to the bench of Honorable Chief Justice before.
No, Lordship.
Anyway, Section 6, contribution matters.
Contribution, my lord, is defined under section 2C. Oh, sorry.
It's all right. But then it's 6 mandates that.
Yes, ma'am.
Lordship, I'll just provide a circular, Lordship, EPF circular, Lordship. Lordship, there I have marked para 3, Lordship.
Yes,
Para 3, Lordship.
yes.
It reads, Lordship, para 33 of the EPF schemes states that it shall be the responsibility of the principal employer to pay both the contribution payable by himself in respect of the employees directly employed by him and of the employees employed by or through a contractor, and also administrative charges.
So that makes him liable.
Liable, Lordship.
But my question here is whether Muda can be termed as a principal employer without being the owner, my lord.
Now, who has allotted the contract?
My lord, the tender was floated by us, my lord, for the government, and we have procured the buses and handed over to the operator, my lord.
No, that means then
The buses are registered.
You are the allotting authority. You have allotted the contract.
I'm just implementing, my lord. I do not owe the bus, my lord.
Lordship.
No money comes to me, my lord.
Lordship, page number 48, Lordship, contract agreement signed by them, Lordship.
As an agency, my lord, my responsibility is to, my lord, complete the implement the scheme, my lord.
Anyway, we'll come to it. Just hold on for a minute, my lord. Just sit down. Now, this section 6 speaks about the formation of schemes.
Yes, my lord.
Now the येता आपण आहोत येते local job speak to him. Yes, okay, this is bad, right? Oh. You're comfortable, you're feeling it's humid.
Little bit humid.
It's humid, my lord.
Then you can know you are on the OCSC. I think it's better. I thought that maybe it may disturb you, so I thought.
No, my
No,
lord.
Lordship. It's a little bit humid, Lordship.
Now, what happens when that money is not paid under the scheme, contribution is not made, then what happens?
The principal employer is liable to pay.
Where is that provision?
14B, Lordship. Section 14B. And thereafter 7Q also is there, Lordship. First 14B and then 7Q. Power to recover damages.
14B is
Power to recover damages. It reads, Lordship, where an employer makes default in the payment.
Just a minute, madam. Now, the payment which you have defaulted, that is under section 6.
Yes.
This allegation is that the payment which you are liable to make under section 6, that has not been made. That is the allegation.
Now, my lord, kindly have section 7A. That is what your lordships is looking for.
The code is basically trying to get the procedures.
Yes, my lord.
How this thing.
Yes, my lord. So 7A, I do understand, my lord, what is in your lordship's mind.
Yes.
7A is, my lord, determination of monies due from employees, my lord.
Yes.
Now it reads, my lord. Now 7A is the proceedings for which notices are being issued. They are issuing notices time and again to me that we will initiate proceedings under 7A and criminal proceedings under section 14.
But then this cannot be done concurrently, can it be? Criminal proceeding in 7A cannot run concurrently. Criminal proceeding comes later.
Later, my lord. Now, my lord, kindly.
Criminal proceeding is penalty.
Yes, my lord.
So that is at the end of the other aspect, all other.
My lord, your lordships is looking for something. Let us read 7A, my lord. But 7A reads, my lord, determination of monies from employees. The CPF commissioner, any so on, may by order A, in case where a dispute arises. This is what your lordships is looking for. In case where a dispute arises regarding the applicability of this act to an establishment, decides such dispute. This is what your lordships is looking for.
That is one of the aspect, not the things. See, like this court was basically looking for the default.
Yes, my lord.
What happens in case when employer defaults?
My lord.
That is what is needed. Anyway, just you proceed. What you want to show it here?
So my lord, my writ petition is regarding the applicability of these provisions, my lord, to Muda. not being an employer,
But then
neither
where
a
does it say?
principal.
See, you have not completed the rating. What
Yes.
what happens?
Yes, my lord.
In a case
Number
where a
one.
dispute arises regarding the applicability of this act to an establishment, decides such dispute. Now, that CPF commissioner has to decide.
Yes, my lord.
So, was there any decision made?
No, my lord. We have come
Then
on the
before,
stage.
before issuing that, if that plea was raised by them, then without doing that, can you further proceed against them?
Lordship, the notice they have now the review of the if 7A is initiated, then Lordship they have to file a review of order under section 7B. Lordship, they directly cannot come to High Court also. If 7A is initiated, then there is a section.
No. 7B is a different thing. 7B pass an order under 7A.
Yes, Lordship.
Where is under 7A?
Lordship,
If that is, say, supposing if they had responded to your notice by saying that sort of employees, this set of employees under the SPTS
Lordship.
cannot be treated as their employees. They will not come under them. Then you should have decided. Then have you decided?
Lordship, after final show cause notice, they came to before this honorable court. They got the stay.
No, but then before that, they have filed a reply before you, isn't it?
After filing a reply, we have again issued a note. We have again issued notice that further, based on your reply, further you provide everything. And moreover, since
Provide everything means what?
all the details.
For what?
Lordship,
You see, this was a plea which basically should have been decided by you.
Correct.
It's a question of law, isn't it?
Correct.
Lordship.
Somebody seeking exemption, saying that they do not come under the purview of the act.
Lordship.
Now, if there is a dispute that law mandates that it should be decided by you 7A.
Lordship.
Now, without deciding that, how can you proceed any further?
Lordship, we have not proceeded. We have just issued a show cause notice, Lordship. We have not proceeded, Lordship. We have issued a show cause notice stating that page number 151, annexure 17 is that if you are not complying and also not deducting 25% from the bill amount to the contractor, we are proceeding. We shall proceed against you. Based on that notice,
But then see the bottom part of your notice, it says about the launching of criminal proceeding also.
They'll file FIR. They'll file FIR.
That is what criminal
no,
proceeding.
Lordship, page 152, Lordship, the bottom part, last proceedings they have challenged, Lordship. 152, please note the, 152 page number.
Yes.
Please note that no further extension will be allowed, and if you fail to submit and call records along with your explanation at called place and time, legal proceedings following the rules may be initiated without any further reference, and you may be prosecuted as per para 76 of EPF. I have not, we will be initiating proceeding against as per para 76 of EPF schemes and read with section 14 of EPF, that is damages, power to recover damages, for which a penalty up to rupees 25,000 and or 1 year imprisonment may be imposed upon you
So you are
under
going for-
7A.
you are
Under
going for
7A
penalty.
proceedings.
Yes.
So we have not passed any order. We
that is-
have just issued a show cause notice.
What is initiation of 7A proceeding?
7A proceedings is,
See, before you initiate 7A proceeding, you have to decide the plea, that whether they come under the purview of the act or not.
they come under the purview, Lordship, because according to the contract.
Where is that order? Show us that order.
Lordship, we have initiation of, after initiation of proceedings,
Have you seen their reply, show cause?
Lordship.
That is page 134 probably it was, isn't it?
Yes, my lord.
They have specifically stated that And your subsequent notice, you have not made them liable for their own set of employees. You are now trying to make employees of SPTS. Then your notice will go. This is a shock cause reply. What decision you have taken on shock cause reply? Mr. Nongri was reading that one. He was referring to those.
Starting from January to November, my lord, 8 or 9 show cause notices have been issued. That is why, despite our reply, that is why we are compelled to come here. We are being threatened with prosecution, my lord. Criminal proceedings, my lord. That is why we had to approach. It is their duty. We have raised an objection, my lord. They have to, under 7A and 7A, my lord, 1A, they have to decide the dispute, whether it's applicable to us or no. Thereafter, my lord, whatever they decide, we'll appeal.
No, but then he has the power to conduct an inquiry for any of the purposes.
Yes, my lord.
Even for determining that. Now, if the authority asks for submission of certain records for inquiry, conducting inquiry into
Yes,
this,
my lord.
so why you should cooperate with that?
We have cooperated, my lord. We have directed all these operators, my lord, which I had also indicated.
Probably
Page 143.
See, Mr. Nongri,
Yes,
I think it will be beneficial if we proceed further.
Yes, my lord.
See, you just see this subsection 2,
Yes, my
7
lord.
says that the court conducting an inquiry under subsection 1,
Pardon your lordship, section 2.
7A. Come to 7A, subsection 2.
Oh, 7A, subsection 2. Sorry.
Now it speaks about conducting an inquiry under section 7, and it has the power to call for these things.
Yes, my lord. So this is these are the powers, my lord.
But then they do not.
He has to decide.
But then he has not done it.
He has not
Without
done.
resorting this.
We have given all the materials.
Yes,
It is for
yes,
them
madam.
to decide.
Lordship, we have called for records, Lordship. It's not that the
No,
matter.
but then your notice itself, whatever you just now, page 155 you have showed us just now,
Yes,
it's
sir.
something different. It just doesn't show, it's not in accordance with subsection 2, 7A, subsection 2.
Lordship, Lordship, page 151, Lordship. Page 151, it is
Yes.
before initial.
No, what is the bottom part of that notice? Which you have read just now.
Lordship, the bottom part, prior to the bottom part, reaching the bottom part, what we have called for the documents is
That
that.
is okay, but then we cannot partially uphold certain part of the notice and set aside certain other part.
Lordship, we
See,
have
before
called for the
completion-
salaries. We have called for. They have not provided us this, Lordship. Lordship, please
how
submit
do
your
you say you have not provided
clarification. Please submit your clarification along with the following documents at our office: list of all contractual employees along with salary and wages, date of joining, details of payment made to the various contractors, details of compliance.
If they do not have, how they will submit it?
Lordship, the details of the contractors along with the salary wages, Lordship, details of payment made to various contractors. They are making payments to the
But then
contractors.
they will not have details of the employees. Let us assume.
Lordship,
Now, in default, what do? Is it not required on your part to hold them liable under the Act?
Lordship,
Pass certain orders saying that they come under the purview of this Act. Where is that finding?
Lordship. Before passing the order, they have come before this honorable court, Lordship.
How can you have issued notice before passing that order? The fact remains that you are issuing notices after notices. When is the first notice?
Lord, January 2018 at page 130.
Page 133.
3, my lord.
15/1/2018, your first notice.
Yes.
And what is the last notice?
Last notice is, my lord,
16/11.
November.
So you take for 1 year, for 10 months, you go on issuing notice only.
Total of 8 or 9 notices.
Just unnecessary bothering. And you see why no legal proceeding should be initiated against you and why not you should be prosecuted. That also you have asked for there. This is not your case that the shock cause which they have filed, you have not received a copy of that. 134, page 134, the show cause reply, you are in receipt of that. Now after, if this show cause reply, what order you have passed, basing on this show cause reply, just show us. Even if you have rejected also, just show us. Otherwise your subsequent notices are not in accordance with it. Just we will quash these notices. We will direct you to pass an order on the show cause reply which they have filed, and take subsequent action in that.
Lordship, in my
One more thing, if I may just indicate, our show cause reply on 9th March 2018, 9th of March. Again, my lord, at page 136, they issue another notice on 13th of March. Now, kindly have the last paragraph, my lord, in bold. Before initiating any legal proceedings, page 136, my lord.
Just a minute. Yes.
Before initiating any legal proceedings, a final opportunity is being given to you as well as all the contractors, and you are advised to direct all the contractors of the buses plying under the Shillong so-and-so to get themselves registered with EPFO under section 2A of EPF. Within
So
March
you have done it. You have, in compliance with this, you have issued rules.
137, my lord. Page 137, 27th of March.
Now,
These
once-
10 operators.
When you wrote this letter, did you forward a copy of this to the EPF authority? You have not made.
My lord, we have informed the EPF authority at page 138, ensuring enrollment and compliance of all bus contractors, my lord. Addressed to the, my lord.
Now, madam, just tell us what order you have passed after this show cause reply, and all
Lordship.
those things have been done.
affidavit, my affidavit, Lordship, Annexure A. Page 6, Lordship. We have written a letter. In this regard, the status of the above contractors are given below. We have given them the status of the contractors. It is further requested to kindly instruct all the bus operators to get EPF code number from this office immediately, and to start compliance of EPF Act, failing which 25% of their bills may be deducted from, or their payment may be withheld till further orders.
So,
Lordship,
how they come becomes this thing? If they, is it their duty? Are they the implementing agency?
because yes, Lordship, because otherwise the
No,
bill
now,
which they
you
are
see,
releasing.
Wait. If that contractor has made separate registration, then they become individually liable now.
Lordship, they are not individual, Lordship. The contractors gets benefits. The contractors gets 25 the bills
Well,
from the.
anyway, whatever the thing issue, we do not want to go to get entangled by all those things. Just tell us what order you have passed subsequent to the show cause reply dated 9th March 2018. We want orders. These are all notices you are showing. You should have rejected their plea. If you still say that even in spite of the registration of those contractors separately, the MUDA still remains liable. Is it Mr. Nongri? They are contractor under you. Now they have separate registration, EPF. Do you still remain liable for their inaction?
My lord, in this case, no, my lord. In this particular case,
So what is the law? By virtue of what circular which Ms. Bhattachi has put here,
Lord, there is a...
But who is the principal employer then?
The state government, if at all, my lord, is the owner of the buses.
See, which employee remains there which employee doesn't remain there, that is the contractor's prerogative. How the Muta will know? So you cannot just saddle them with that responsibility of doing all those things.
And my lord, the deduction which they have been insisting that we should deduct from their bills, my lord, these operation of bus, we don't pay the bills, my lord. It is the operators who has to pay the government, my lord. It's not that we have to pay them after completion of
You see,
work.
probably you do not have to go to that much thing.
Yes, my lord.
Lordship,
Until
miscellaneous.
unless there is a determination or inquiry under 7A, I
Lordship,
don't think they should not have proceeded against you.
Lordship, miscellaneous application 145 of 2019, Lordship.
What is that miscellaneous application? What for that miscellaneous application was there?
Lordship, there, all the orders are there. The adjournment notices under section 7A.
No, just tell us to take us to that direct order by which we have rejected their plea or accepted their plea.
Lordship, when we call for summons, Lordship, when we have issued summon, Lordship, thereafter they constantly applied for adjournment application, Lordship.
That is no answer to the query of the court.
Order
Their
can be passed
adjournment,
under.
where the adjournment entitle you to bypass the provisions of law. You should
Lordship,
decide, once that issue is this thing taken, you should decide it, and without deciding it, where you have done it.
Lordship, once we have issued summon, Lordship, then they are supposed, annexure 2, Lordship, summon to appear under section 7A, Lordship. Miscellaneous application 145 of 2019, Lordship.
7A, where is that? Where? No, this miscellaneous application is for what? You just get
It is filed.
miscellaneous application is for what? No, where is the details given in your affidavit? You have not taken any stand in your affidavit. Nothing is there. See, summon is not your order, isn't it?
No.
Summon comes in consequent to the passing of order. Where is your order?
Lordship, after sending summons, Lordship, after they started adjourning, sorting
Just
adjournment.
we want the order passed by you consequent to the filing of the show cause by the petitioner. Just tell after 9 March 2018.
Lordship, I'll just take instruction from the department.
Please, you have to give. See, otherwise we will interfere with these things. And without disposing that, you cannot issue any further notice in respect of those employees. And admittedly, what Mr. Nongri has pointed out, that now you do not have any grievance with regard to his set of employees. Your grievance is only with regard to those set of employees. And if with regard to those set of employees they have raised that issue, you have to determine that issue before you proceed any further under the Act.
We have, Lordship, we have issued summons. Lordship, I'll just find out whether there is any order or not. But Lordship, we have issued.
If you have issued summons and if they have at all not responded to the summon, thereafter also you should have passed some expert order against them,
Lordship,
holding that they are liable, and thereafter you should have proceeded for this thing, notice for non-making contribution before taking punitive steps.
Lordship, according to the contract agreement, page 48, Lordship, they are the ownership of the
Maybe these are all matters of merit. We are not going to merits. Read court will not give any finding of fact until unless it is necessary. We are concerned about the procedural aspects. Even this initial at the very first stage, we have pointed out to Mr. Nongri that if this order passed under the Act is applicable, we will not entertain this read. But then he has made out a different case. It is not a case that the order passed under 7A, which is appealable, and by passing this appeal, he has come before this court. He is correct in holding you have not passed any order under 7A until unless you can show it, and that is not there. If you show it also, then you should make them know that you have passed an order and their plea has been rejected. Where is that? You have not intimated them.
Lordship, I'll get instruction in this, Lordship.
When? Tomorrow?
Tomorrow, Lordship.
We'll have it tomorrow, Mr. Nongri. Or not, tomorrow is Wednesday. We may have some other matters also fixed tomorrow, isn't it? 2 other matters on Monday. Day after?
Lordship.
have to do.
Because once we have got some issue, why to go for these things? This probably can be disposed of on the basis of what has been pointed out right now. If that is what, then we'll just simply pass an order. We'll interfere with all your notices. We'll send back that matter to you. We'll pass first an order under 7A after holding inquiry. And then thereafter, if you determine the status of those employees, then only you will proceed against the rest of the authority.
Lordship.
Is it correct in law?
Yes, yes.
Do not take advantage of the ignorance of this court.
No, my lord.
Do not be happy that the court is taking view,
No, my lord.
but without knowing law.
I'll be the last person to do that, my lord.
At least have the court
Yes, my lord.
pass correct order.
That is why, my lord, I took your lordships to 7A because I understood what your lordships were looking for.
Okay, heart, Land Council purposes. At the request of Miss P. Bhattacharya, this is matter of day after tomorrow. Your date. Interesting. See, honestly, this court doesn't have any basic idea about this. So you have to,
My lord.
it's like without knowing the basic, it becomes very difficult
Yes,
to decide a matter.
My lord, though in the matter is very tempting to go into definition of
This is
all
not
those,
required. You
but
see,
not required.
See, one
Exactly,
thing
my
is
lord.
that the basic concept of principle of natural justice. You see, certain things is provided in the act. Now, if law provides that yes, there is a like the scope of raising the dispute with regard to the application of act,
Yes, my lord.
and the law says that there is a procedure for holding an inquiry, that should be done fast. It cannot be something like that you issue notice, taking opinion or threatening about penal action, and then subsequently the end party will decide the applicability. It cannot be. First thing fast. You have to decide it first, maintainability of the things, then only. So that is what. If it is not there, then you have to take back those notices. You have to first decide and then proceed. First decide under 7A by holding an inquiry, the specific plea taken by them.
Lordship.
If you are unable to point out before this court a place and order by which you have rejected their plea,
Lordship.
then your notices will be held. These things.
Lordship.
This will be interfered with. That is what it appears to be, and may not be a final decision.
My lord.
But then we'll not go beyond that.